Criminal passage number 3 start. On the other hand, learned advocate Supreme Court ASC for the complainant oblique respondent appellant in cross criminal appeal number 414/2003, however, vehemently contested the above arguments. He was of the view that once the guilt of the appellants has been established and believed by the trial court as well as by the High Court after proper appraisal and pre-appraisal of the evidence, then there was no occasion or room left out for the reduction of the two appellants' sentence from death to life imprisonment. He further argued with vehemence that all the accused had come to the spot duly armed with lethal weapons and jointly attacked the two deceased with common intention, causing both of them fatal injuries through daggers, hatchet, and butcher knives. Therefore, the case of one or other accused could not be sliced away, nor it can be distinguished on any factual and legal premises from that of the three appellants. Thus, he further contended that the acquittal of Liaquat Ali, respondent, and altering reducing the sentence of Amanat Ali, respondent, from death to 14 years rigorous imprisonment have got no sanction of law in view of the well-settled principle that liability of each one of the accused for the purpose of awarding sentences was one and the same. Hence, the impugned judgment of the Lahore High Court is liable to be reversed to that extent as in his view the same suffers from patent error of law. As the learned advocate Supreme Court has confined his submission to reduction of the sentence of the two appellants on the grounds mentioned in the earlier part of this judgment, therefore we have to determine this question of vital importance as on merits of the case besides the conceding statement by him at the bar. We, after careful reappraisal of the evidence, have no legitimate cause to take exception to the view held by the High Court even in the unamended provision of S 302 PPC. The punishment provided for murder was death or imprisonment for life, and the offender shall also be liable to fine. The change introduced by the law commonly known as Qisas and Diyat laws amending S 302 PPC. The same has been divided into three parts, that is A, B and C. In clause B, the legislature in its wisdom has added qualified words to clause B of S 302 PPC which reads as follows. B shall be punished with death or imprisonment for life as tazir, having regard to the facts and circumstances of the case, if the proof in either of the forms specified in S 304 is not available. After careful reading of the above penal clause of section 302, it becomes debatable as to whether the normal penalty is death for offense of murder and be given preference invariably, or the sentence of death and the life imprisonment are two alternative sentences as provided in the amended clause B, preceded by a qualifying phrase as tazir, having regard to the facts and circumstances of the case. If the proof in either of the forms specified in section 304 is not available, this aspect of the matter has already been commented upon by this court in the recent case of Hassan and others versus the state and others PLD 2013 Supreme Court 793. Full stop and close.